Hello friends, greetings to everyone watching the video. I'm Reshu. I'm managing editor of Apricus Journals, an imprint of Apricus e-learning solutions private limited. I welcome you all to Convo with Apricus, and we have with us today Mr. Kaustuv Ghosh for the discussion on efficacy of law in relation to reservation policies in India. Welcome, sir. Kaustuv
Thank you.
is a promising lawyer in Kolkata High Court, and within a short span of time, he has achieved a lot in his career. He is our honorable member of editorial board in Justice and Law Bulletin, one of the journals in the bouquet of Apricus journals. We will now proceed with the discussion. So, my first question is, what is the stand of law with respect of reservation policies in India?
Before we proceed to discuss the laws, and we have to first think why reservation was initiated first, and for what reason it was initiated, and what is their background. Now, we have in India there are different languages, caste, creed, etc. And if we look into the Vedic period, there are usually these now we have that caste system which was introduced only because of to distribute the labor, division of labor, and that's why I want to quote some hymns of Rig Vedas, that is one to high sway, one to exalted glory, one to pursue his gain, and one his labor, all to regard their different vocations, all moving creatures had that down awakened. This is in Rigved first mandal hymn 113. And if and in 10th mandal of Rigved, slok number 90, that is the Brahman was his mouth, of both his arms was the Rajanna made. His thighs become the Vaishya, and from his feet the Sudra was produced. And if we come to the Gita, that is 4th chapter, here Lord Krishna said, Chatur Varnam Maya Srishtam Guna Karma Vibhagasha Tasya Kartaramo Mam Vidha Kartaram Avayam. And in these three slokas, we can find that it is just only there are Brahmins are there to teach, Kshatriyas are there to protect the nation, society from external threat, Vaishyas are there to maintain the economy, and Sudras were there to help for labor issues, whatever. And unfortunately, post-Vedic period, when there was a political, there was a motive of political gain or power politics, that situation just got changed, and that's why Brahmins or Kshatriyas for power greeding motive thrashes Sudras, and they were treated as untouchables, and that's why in fact they are not treated fairly. They were not even allowed to drink water from the well, and it was continued till British period also. And that is why in fact that is why in the British period we can check, that is in Government of India Act 1919, yes, 1919. And we can, if we can check Minto Model reform in 1909, and if we can check in Simon Commission report, Montagu Chelmsford reform, and there is Pune Pact 1932. There are some certain provisions for minorities, but after we got independence, we adopt a constitution to secure equality status and opportunities, and to promote among them all, because in the eyes of law everyone is equal, and those backward sections were deprived of their livelihood, and that's why to ensure that reservation was introduced. And we have Article 15, Article 16, Article 17. in directive principle of state policy, we have Article 39A, Article 45, and we have Article 330 to 340. We have all the provisions, legal provision, which talk about reservation.
Thank you, sir. Thank you so much for your views. Could you just show light on Article 15(4), special provision for advancement of backward classes?
Yes, and Article 15 talks about right to equality. And Article 15 tells the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. And that is, but Article 15(4) says nothing in this article or in clause 3 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and scheduled tribes. And before I proceed to talk about Article 15, we need to know there are scheduled castes which are usually previously known as Sudras, and we have scheduled tribes. They are usually known as who are Adivasis, like Santal, and there are other backward classes which were not included in SC/ST, but they were financially or otherwise backward, and these three are mainly reserved category. And for them, why this exception clause Article 15(4) was introduced? Because in the view of equality, there need to be a reasonable classification. Like we can see, there is some meme that there are one 6 foot height people, there is one 5 foot height people, and there is one 5 foot 6 inches people. They are watching a football match. 6 foot don't need any help to saw it from a 5 foot barrier. Who is under 5 foot, he needs 2 or 3 help or eat brick, and 5'6" needs 1 help. And this is called reasonable classification. When you are promoting everyone, you need to give some special protection to the backward section who are deprived till who are deprived from the last 1,000 of years. If they are need to introduced, then we have to protect them. We have to preserve them. We have to preserve their. We have to feed their hunger. We have to ensure their education, because previously, in fact, Baba Sahib Ambedkar, the chairman of drafting committee of the constitution, even suffered from this inequality, and that's why introduced this kind of provisions to ensure everyone. When you are protecting minorities, irrespective of religion, irrespective of language, when you are protecting minorities, you are protecting everyone. Because if we are protect minorities, we cannot be minorities in other part. We may be majority in one part, but we are in minority in other part. When we are taking care of minorities, we are taking care of majorities as well. And that's why there is a reasonable classification, and that's why Article 15(4) was introduced. And for that, I want to quote a case, that is State of Madras versus Chambakam Dorai Rajan. In this case, Madras government had reserved seat in state medical and engineering colleges for different communities in various proportion on the basis of religion, caste, and race. And the state defended the law on the ground that it was enacted with a view to promote the social justice. Yes, that is the important thing. So we have to ensure social justice, and for all the sections of the people are required by Article 46 of the directive principle of state policy. But Supreme Court held that law void. But after that, Parliament introduced this amendment, and if we can look into our preamble, there is justice for all, equal opportunities for all. If we are aiming to protect all, then we have to give certain privileges to that section who was deprived till now. This is the main issue I felt. And for the social justice, even Uh, uh, Now we can, yes, that's all.
Thank you, sir. Thank you for your views. We will now switch to next question. Could you please tell us about the Constitution 93rd Amendment Act 2006, which is provision for reservation of backward SC and ST classes in private educational institutions?
Yes. Now, before I proceed to speak on this, I want to quote Swami Vivekananda, that is, education is the manifestation of the perfection already in a man. If we are educating the youth, we are securing our future, because our future is our future lies in the hand of our future generation, and that's why there are some who are usually who was deprived till now. In fact, they are may not be, they are economically stable, and we know that we have population explosion, and that is why uh, those government schools are not sufficient to accommodate everyone, and that's why private private schools or private educational institutes was in, private educational institutions was introduced, and that is why this provision was enumerated, because to ensure that they are not even deprived in other private educational institutions, and they can secure their higher educational aim, and so that they can join building the nation. Everyone should join to build our nation. Everyone is needed, irrespective of their titles, irrespective of everything. We need everyone, be it be it any religion, be it anyone, everyone. We need everyone, because when we are together, we are bigger, we are better.
Yes, sir. So, could you please show some light on back a reservation for backward classes in public employment?
Yes, and Article 16 talks about this, and Article 16.3 is an exception to clause 2 of the Article 16, which forbids discrimination on the ground of residence. Now, Article 16.3 what says? There should not be any discrimination on the ground of residence. But why it was introduced, this exception clause? To ensure that, because if we look into the places where scheduled tribes lived, and for a they suffer. In fact, I have heard that some people could not afford half quarter meal, I will say. They have to eat those egg of the ant, and they have to eat sometimes mud. And I feel this was introduced because to ensure that they can tackle their own problem. And Article 16 was embargo, because there should not be any discrimination about their residence, but it was introduced as exception, because it was introduced to ensure that those people who are belonging to this backward class, they can ensure their progress, and that's why those places were reserved for those, because they know the condition better than anyone else. Like an example, you live in a place and you know that place very well than me, and if the government allows you to do something better for your locality, you will do it better than me. This is the same logic. It was introduced. In a short,
Yes.
we can say that.
Sir, could you please tell us something about one landmark judgment with respect to reservation in India?
And there are many judgments are there in this reservation, and one is that is Indro Sahani versus Union of India. It is famous as the Mandal case. And in Supreme Court there was 9-judge constitutional bench by 6:3 majority held that the decision of the Indian government to reserve 27% government job for backward classes, provided socially advanced person, creamy layer, among them are eliminated, and that is an reservation of seats shall only confine to initial appointment, not to promotion, and to total reservation shall not exceed 50%. This is the main thing. There are many judgments on reservation, but this is, I feel that this is most important, that Supreme Court fixed that reservation should not exceed 50%, and there is a mention of creamy layer person. And the yes, yes, that is all. That's all.
Thank you, sir. Thank you for your time you took out from your busy schedule and you shared your views on the topic. I hope the audience will be benefited from your views. Thank you so much.
Thank you, madam.